Welcome to the Napa Legal Weekly Podcast. I'm Mary Margaret Bush, Napa Legal's Executive Director.
And I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofits. We have a really good host of cases and issues to talk about here this week. We're going to be covering the U.S. Supreme Court's decision that came down in Wisconsin Catholic Charities on June 5th. Then we'll turn to a legal battle in Vermont over whether Christians can be refused foster parent licenses fighting by their faith. And then we'll wrap up with a recent decision by the Department of Health and Human Services to rescind its emergency abortion mandate. So with that, let's get to it.
Thanks, Frank. It's always exciting to start off with a Supreme Court case. So we'll talk first about the Wisconsin Catholic Charities versus Wisconsin case, which was decided. The opinion came down yesterday. As some of you might remember, this was a case that presented the question of whether Wisconsin violated the First Amendment's religion clauses by denying Catholic Charities a tax exemption otherwise available because the organization didn't meet the state's definition of religious behavior. And the specific definition the state was proposing was proselytizing, which is actually discouraged, if not completely prohibited, by the applicable pastoral council that covered Catholic Charities. So the Supreme Court's holding was very encouraging. And I think this is also a case that we found from the beginning to be very refreshing. There are a lot of cases that kind of focus on fraught, kind of emotional culture war issues. This was a 9-0 decision. And I think what we can take away from that is the fact that the underlying foundations of religious liberty are very much intact. There's a monolithic consensus that religious liberty matters in our country. And as we explore some more kind of novel applications and the logical conclusions based on that religious liberty, we might encounter a few setbacks, as with St. Isidore. But I think it's very encouraging to know that underlying it all, there is a 9-0 support for religious freedom. So let's get specific. The opinion was written by Justice Sotomayor, and she held on behalf of the court that the Wisconsin Supreme Court's decision denying Catholic Charities Bureau tax exemption, otherwise available under Wisconsin law, violated the First Amendment because it discriminated along theological lines. And so basically, the theological question of whether or not it's right to proselytize while providing humanitarian or corporal works of mercy actually discriminated between faiths that do encourage that and faiths that discourage that. So Justice Sotomayor really focused on the Establishment Clause violations here. She kind of knocked it out of the park, took the straightforward Establishment Clause violation, prioritizing one type of theological teaching over another. I thought there was a lot that was very encouraging in her opinion. I also found Justice Thomas's concurrence to be extremely interesting and quite close to our heart because he focused on church autonomy and the interaction between the kind of theological spiritual existence of a group of religious people and the corporal, almost technical implications that has in the world. And so he talked about church autonomy, broke it down into the three components. The first is right of association, religious groups' right to come together without undue government interference. The close link between theological questions and church governance, which is near and dear to our hearts. And I'll quote a little bit more in detail from that in a minute. And then finally, he talked about the spheres of sovereignty. There are certain areas where the state power is not unlimited. We know that, but we often kind of forget that. Or at least some people in power forget that. A couple of favorite quotes from his opinion. He says, establishing corporate identities is essential for religious institutions to manage their temporal affairs. But the church autonomy doctrine forbids treating religious institutions as nothing more than the corporate entities they form. And then he talks about how religious institutions need to buy and sell property, hire and pay staff, form contracts, file lawsuits, property management, personnel changes, all things near and dear to our heart at Napa Legal, things we try to help faith-based nonprofits do, these temporal affairs that are not at the core of what a religious institution does, but are very much integral to what it means to serve in the world, in the city of man. And he then kind of raises up from that and says, at the same time, these organizations, although they have legal personhood and kind of interact in the same world as like a group selling widgets, there's so much more going on. And the state, he says, is these institutions exist on some level, a parallel to the state, and the state has no legitimate role in defining the structure of religious organizations' polity. And then finally, he just concludes by saying, "I would have reversed not only because of the establishment clause issues and the discrimination occurring, but also for an additional reason. The Wisconsin Supreme Court violated the church autonomy doctrine because, however they're incorporated, Catholic Charities is part of the church, the Diocese of Superior, and the Wisconsin Supreme Court should have deferred to that understanding, and by failing to do so, unlawfully attempted to redefine the church's internal governance." So what a beautiful decision. What a wonderful thing to see a 9-0 ruling on this important issue. And I think kind of zooming out, it's a wonderful decision. I highly recommend reading it. Zooming out, I think this is actually a very, very important decision. Sometimes I think if you see a 9-0, you're like, well, maybe this wasn't controversial. I don't think it was controversial, but I think it could have become controversial. And so I think this is one of those decisions that I think will trickle down to district court cases. This will help with motions for summary judgment. This will help religious organizations proceed confidently in their understanding of how their relationship with the state will work, in a way that I think that was really left unstable after the Wisconsin Supreme Court's decision and kind of the line of thinking they laid out. So a great decision, I think, from a legal perspective, and a great opportunity from a cultural perspective to affirm the contributions and productive aspects that religious organizations bring to society. So Frank, we've been following this case for a long time. So many questions for you, and would love to hear what stood out to you in this case, and what do you think we can expect moving forward?
Yeah, this is it's a good one. And it's like you said, when you see the 9-0 and you see that it's written by Justice Sotomayor, my first instinct is like, oh, is this going to be so narrow as to be like an unhelpful precedent? And it's not. It's a really good, even the majority opinion from Justice Sotomayor, I think is very good. And I just want to back up and make one practical point here because I think it's worth highlighting, right? That the Wisconsin decision at the Wisconsin Supreme Court level was based basically in this idea that religion should be cabined to very narrow kinds of activities, right? And when pushed, the Wisconsin lawyers at the Supreme Court actually doubled down on this argument. I'm trying to find the quote. Oh yeah, the lawyers for Wisconsin said, well, we're asked, well, then what does qualify as primarily a religious activity, right? What makes you operating primarily for religious activities? And the lawyer said, well, it's limited to those activities that, quote, express and inculcate religious doctrine, worship, proselytization, religious education. And I mean, frankly, that's crazy, right? Because to say that, well, that's what a religious activity is and nothing else is, it's particularly egregious in a case like this with Catholic Charities, with Christians doing the corporal works of mercy, because you don't have to go too deep into Christian doctrine. You can just kind of read the Gospels to see that feeding the hungry, housing the homeless, preaching, praying in the streets, these are all religious works because they're mandated by the gospel, right? So to say that, well, feeding the hungry, housing the homeless, helping the disabled, those aren't primarily religious because a secular organization can do the same thing. That's crazy. I don't mean to put too fine a point on that, but you're taking some clearly religious activities and saying, well, they're not religious because non-religious people can do them too. And I think that gets you into an area where almost nothing is a religious practice. Right? I was reflecting on this for a piece I'm writing on this case and thinking to myself, well, so is meditation, for example, like meditation on the gospel, is that not a religious practice? Because secular people can meditate to seek mental clarity, right? If a Catholic is fasting on Good Friday, maybe that's not a religious practice because secular people might be fasting that same day for the physical benefits, right? At a certain point, if the test is, well, it's got to be something that doesn't have a secular counterpart, that's not the right criterion for what is a religious practice. And the dissent in the Wisconsin Supreme Court nailed this and said, no, when the motivations behind an activity are clearly religious, irrespective of the nature of the activities, that's a religious activity. And that's right. And I just want to point out that I think Justice Sotomayor was very focused on this issue and got it right. But she also, I think, drew a good conclusion to say, well, the problem is that is a doctrinal discrimination, right? Because then what you're saying is, okay, if there's a religion that doesn't care about doing anything except proselytizing and, teaching religion and serving its own members, that's a religion. But if you have this universalized religion that actually also cares about doing corporal works of mercy, irrespective of whether the recipients are Christians, that's not a religion. That's a doctrinal choice, a very strange one, as I pointed out, a crazy one, because it cabins religious activity. But it is also a discriminatory choice to say these are religions, these are not. And I don't think there's any justification as to why a court would or could make that distinction, right? There are definitely, and I've done a lot of work on this, so I won't belabor it. It's a pet issue, but the court does have to draw lines between what's a religion or what's not, right? Or else religious liberty is a meaningless protection. But drawing the line this way made no sense. I'm glad to see a unanimous decision calling it out and saying, no, that's not the proper way or a legitimate way for courts to draw the line between what is and is not a religion.
I think that's such a good point, Frank. And I think this is one of those, sometimes you see overt attacks on religious freedom, and then other times there's sort of this death by a thousand paper cuts thing going on. And I think the ambiguity that was on the books before this decision was posed a serious risk. And so I think the Supreme Court's intervening with clarity here marks a great, I think we'll build momentum in the right direction. And speaking of doing so, I think we have an interesting foster care case. I'm really looking forward to hearing you, as the our resident foster care and religious liberty expert, your thoughts on this.
Yeah, this is an interesting one to turn to now. So we've seen iterations of this happen before in other states. I think it was just recently, this case was appealed to the Second Circuit after an adverse district court ruling. Alliance Defending Freedom, I believe, is representing the plaintiffs in this case. So there's a Vermont law that basically categorically excludes large groups of otherwise qualified people from becoming foster parents. And it's based in the idea that families or foster parents in Vermont to be licensed must agree to hypothetically affirm a child's sexual orientation, gender identity, and so on, in order to be eligible for a license to foster children. Now, this is not a facts and circumstances test, because that would make sense, right? Where the case of an individual child, maybe a believing Christian parent is not going to be a good fit for that parent. I would argue that that's a legitimate distinction to make. You do have to look at the needs and the situations of a particular child before matching them with a foster parent. That is not what's going on here. What happened here is there was a particular family who had adopted several children, had fostered children for years in the Vermont system, were denied a renewal of their foster care license, essentially because of their Christian beliefs. And what happened is the licensing agency in Vermont, and this is complicated, but they're technically private licensing institutions, but they have to abide by criteria set by the state. So it's kind of a public-private hybrid. We saw this in the Fulton versus Philadelphia case. So they're private agencies, but they're working on behalf of the government to certify foster families. So the foster agency asked this family if they would support youth that identified as LGBTQI plus. And the parents replied they would love any child unconditionally, right? They would take any child, love that child, but no, they would not use pronouns inconsistent with the child's biological sex. They wouldn't take hypothetical foster children to pride parades and so on. This is actually on the record. I'm not making up hypotheticals here. And as a result, they were denied the renewal of their foster license. So ADF filed suit. It's now pending in the Second Circuit. There's a free speech claim because this would literally compel speech, right? Yeah, you would be forced to use certain pronouns and names and so on in order to be a government licensed foster parent. There are also free exercise claims because this clearly targets religion. And I think that's the most interesting part of this case. The Vermont authorities claim that this is an even-handed thing just to make sure that all licensed foster parents meet the needs of each foster child, right? And ADF pushed back in their filing, and they point this out. Vermont insisted that this policy is applied even-handedly, requiring families to treat an LGBT child the same way it requires them to treat children of a different race or religious background respectfully. But then ADF goes on to say, Vermont concedes that it does not require families to support and encourage a child's religious faith or identity in a way that would force them to compromise their own beliefs. To me, this is the huge problem in this case, besides just the blatant general religious liberty problem that you can't force Christians to do unchristian things in order to participate in civil society. But it's not applied even-handedly, right? And so if you flipped it the other way and you had, a believing Christian child from, a problematic circumstance where they're in the foster care system, and you have an atheist foster family, the Vermont explicitly said that no, of course they wouldn't require the family to, support and promote Christian doctrine. You can't do that. That forces them to compromise their own beliefs. But then suddenly when you flip the script and say, well, what if it's a Christian foster family with a boy who identifies as a girl? Well, no, you have to support them because we need to support the needs of each child. So apparently that needs of each child applies to LGBTQ identifying children, but not to Christian identifying children. I think that brings in a clear viewpoint-based discrimination problem on both the speech and the free exercise issue. And so it's not even-handed. This is a huge problem legally, and I hope that the Second Circuit will face that honestly. It'll be interesting to see if this is the case that brings this issue up to the Supreme Court, because we've seen it on the licensing agency side. We haven't seen it at the Supreme Court yet on the foster family side. And then I just want to make clear one particular point that doesn't often get discussed, and I think I've probably talked about it on this podcast before, but it gets missed, and it blurs this whole issue. So the idea that foster parents have to be hypothetically ready to embrace like every LGBTQ teenager or confused 10-year-old that might be placed in their household, or else they're not fit to be foster parents, it doesn't comport at all with the realities of how foster care works. And I've said this to you, Mary Margaret, off camera before, but I've worked in children and youth services, right? So when you match a foster family with a child, it's very facts and circumstances specific. There's not just this pipeline where you have X number of foster children, Y number of foster families, and it's like, okay, child number 2 needs a home, we're going to put him with family number 2, 3 needs a home, we're going to put him with number 3. And so every family needs to be ready for every kind of circumstance. That's not how it works. We have a major shortage in this country of foster parents, and they both because they're free human beings and because that's how the system works, they can say what they want. Like foster families are free to say, we're really only a good fit for like Christian children because that, or at least children whose families are open to Christianity because that's how our household runs. And so, an atheist 15-year-old who identifies as transgender, probably not a good fit for us. There's no need to strip them of their foster license. You just don't place that child or a child in that kind of situation with that family. No problem. We do this all the time in the foster care world. And the other thing is people can be choosy even about ages. And this is very normal. You'll have families say, we have little kids in the house from our own biological children. We can't really take teenagers. It's not a good fit right now, especially teenagers who maybe have some of the emotional issues that foster children tend to have. So families can just say, we're really only in a place to take foster children under the age of 2, at which point there's no LGBT issue ever because you're taking in babies, right? So if foster agencies and county or state children and youth services agencies want to say, we're not going to give LGBTQ youth or even children over a certain age who are in public high schools to devout Christian families, I can see the case for that. But to strip them across the board of their foster care certifications and licenses because they won't adhere to the secular faith of LGBTQ, it's not necessary. It's taking an already foster parent shortage situation and making it worse. It's, I think, blatantly unconstitutional, and there's just no need to do it. There's a much narrower way to treat each child and each foster family on a case-by-case basis. I hope this gets struck down quickly, but it's just, I can't underline enough how unnecessary and burdensome this is.
Frank, one thing I've learned from you as we've talked about these foster care cases is that the bedrock of the whole thing is the best interest of the child. That's at the foundation. So as you said, that's woven in. And so I think for just the raw aggression of a particular ideology to come forward and say, when you're thinking about the best interest of the child, our opinion should always trump this opinion. And in putting aside principle, which I don't think we should do, but just let's say some people do that. The jury is very much not conclusive that any of this is in the best interest of children. And so the fact that the bedrock is already there for this to be taken into account, and then um, and then to try to override that by saying actually regardless of what's in the best interest of the child, and in some cases a placement with a family that does have that perspective might be the exact right household depending on the child's own history, and often maybe. And so the override is appalling. I think the other thing that came to my mind is hearing this from a legal standpoint. it kind of connected two separate cases in my mind. The Fulton holding, where we found that, where there's a series of discretionary exemptions that are made to a particular program, but those exemptions are not extended to religious groups. That's unacceptable. And um, this basically the whole foster care system is a system of discretionary exemptions. Every single case is a discretionary judgment call, and so I would think allowing any kind of consideration except faith to come into play absolutely falls into the category of unacceptable constitutionally. And then I also was thinking about the Bella Health case out in Denver, where the court held that where you have a general rule that doesn't expressly target religious groups, but is clearly only going to impact religious groups because it's impacting conduct that's religious. That's also unacceptable, and I think we have that here as well. This barring of families with this perspective, biblical viewpoint from a program otherwise like open is falls right into that category. And then lastly, I think what worries me and saddens me most is how the best interest of children are not even part of the conversation in this case at all. I'm sure it's discouraging for you, Frank, after your work experience in this area.
Yeah, and my goodness, I don't want to belabor, but excellent point about the best interest of a child. If you want to see how this works out on the ground, when you have already a shortage of foster parents, and then you start excluding Christian households who are by and large happily married, stable households, what you end up getting is, I mean, you get these poor understaffed and overworked agencies scrambling to find a foster home, and sometimes it's like, this foster parent, like, he's okay. We kind of have this idea that he's in it for the stipend that he gets per child, but we need to put this kid somewhere. Or there is no foster parent open who wants to take this child, so they end up in a group home. I mean, my goodness, to deny these children a home because the parents have Christian beliefs, where they end up instead is just, these are real examples. I'm thinking of particular kids from my time in this line of work. It's detrimental. It's unacceptable. It's already a shame and a tragedy that we don't have enough foster parents. So to exclude healthy, stable families on these ideological bases is just, it's such a scandal. And I guess I'll leave it at that.
That's so well put. It's it's a sobering topic, and I'm happy we can close on a somewhat positive note here. We're talking now about the an update to the enforcement of EMTALA. So EMTALA is the Federal Emergency Medical Treatment and Labor Act, and it was passed in 1986 to help people in emergency situations receive life-saving care. So nothing controversial here, at least nothing that should be controversial. But unfortunately, uh, we ended up seeing another example of coercive ideology coming into play. And in 22, after the Dobbs decision was issued, activists within the Biden administration attempted to co-opt EMTALA to preempt state laws protecting the lives of the unborn through a clever broadening of the situations in which abortion would be required, and at least indirect narrowing of the situations in which religious and conscience objections would come into play. And so this was litigated in 2024 in the case, I believe it was like Moyle versus United States and Idaho versus United States. Got up to the Supreme Court, beautiful briefs from the Thomas More Society representing the Catholic Bar Association, Christ Medicus, Catholic Healthcare Leadership Alliance. Beautiful briefings, probably still worth a read here. But the Supreme Court did dismiss the case at the time. No reason was given, but I can imagine that perhaps it being 6 months away from an election in which a change in policy was likely, perhaps it seemed premature to make the decision there. Um, and so the good news is that in the end, the Health and Human Services Department just announced that the coercive sections will be rescinded. So the core of EMTALA will be enforced. Life-saving treatment will continue to be required in everything, but at the same time, religious and conscious objections will be better protected, and the attempts to kind of broaden this to enforce an agenda are going to be curbed. And so I wanted to just use this opportunity as well to highlight the work of Catholic Healthcare Leadership Alliance, American College of Pediatricians, and other groups that are trying to make sure that healthcare still focuses on healthcare and is not taken captive by agendas that are not linked in any replicable way to good outcomes for patients. So um, lots to lots to process here. Overall, a very encouraging thing. And I also think I remember, last year there was some concern about whether after the election whether the Department of Health and Human Services would be unapologetically pro-life. So I think this is certainly another indication that the momentum is in that direction, and that not only is there more than neutrality, there's positive momentum in the direction of protecting unborn life. So this was encouraging for me. Frank, I would love to hear your thoughts on this, as well as how you think this connects kind of more broadly to the pro-life movement and what we may expect in the coming years.
Yeah, I think that this is an issue where clarity and distinction making is really important, because I think the messaging the pro-life movement hasn't maybe done the best, or maybe it's just hard to have a voice that gets public media attention here. But th- they're co-opting laws that are not meant for situations like this to advance the abortion agenda. I can't see any other way to read expanding the abortion situations in EMTALA. And I'm not a bioethicist, I'm not a doctor, but from what I understand, the the situations in which a direct abortion is required as an emergency service to like save the life of a mother is, it seems like it's rare, if ever, that that's the case. That it's one thing where, there's an emergency situation and a pregnant mother needs treatment that's going to harm or possibly end the life of the unborn child. That's not an abortion, right? That's medical intervention that has the indirect effect of maybe ending the life of a child. That's a tragedy, but it's categorically different from abortion. The situations in which there's an emergency, we need to abort a child, right? Directly end the life of a child. From my understanding, that doesn't really happen. And so I think that these are often like very sympathetic sounding ways. Well, of course, if the life of the mother is in danger and there's an emergency situation, we should provide an abortion. I don't think that happens all that often, if at all. And I think we need to be very loud and clear about this, that this is not the pro-life movement opposing emergency measures to save the life of a mother. This is the pro-life movement opposing kind of sneaky attempts to use very sympathetic emotional situations to expand abortion access improperly.
That's very well put.
So I think we will stop here. A lot to reflect on, from the Supreme Court to Vermont State Court to Vermont Federal Court to HHS. We've got a lot to chew on for this coming week. And with that, thank you all for joining us for this episode of the Napa Legal Podcast. If you enjoyed the content we're putting out, as always, we would appreciate it if you like this podcast, subscribe to our channel on YouTube, Spotify, or wherever you're listening. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty, and particularly the work of faith-based nonprofits.
Thank you, Frank. We would also like to send a special thank you to our content and program manager, Joseph Clement, as always, for his work preparing these weekly updates, as well as our community manager, Helen Rothfuss, for her work getting the word out on our content. So we will talk to you all next week. Thank you for joining us, and God bless.